Hello, everyone. Welcome to our BlueLedge webinar, Overcoming Court Reporting Dilemmas. We're going to give a few seconds for Zoom to kind of kick everybody in here for us. I'll just give a few seconds. For those of you on the East Coast tonight, thank you for allotting your evening to us. We promise to keep this lively and help you stay awake. And those on the West Coast and Central, you've probably had a very busy day and you're here after a nonstop day, and we appreciate that. Thank you so much for your time. See some familiar names coming in over on the attendee list. That's great. Thank you, everyone. I tell you, we have an amazing panel of experts for you today, and I'm so excited for you to hear their thoughts and to benefit from their decades of experience. And since we're right about time, well, let's go ahead and start. We'll start kicking it off for you. I'll introduce myself. My name is Tamara Candeloro. Some of you may know me as Tammy. I'm actually in a new role here at BlueLedge as the enrollment manager. I first learned of this amazing industry in 2018. A good friend of mine who had actually been a digital reporter since the 1980s introduced me to this field. And I'll tell you, I loved it ever since, from the start, and I just never looked back. I began training and then working as a digital reporter and transcriber. And then I was very excited when I had the opportunity to come over on this side of things and be on the operations and managerial side, where I could extend my efforts to help others to succeed in their careers and to love the industry the same way I have. So here I am today, and I'm humbled and honored to be your host this evening. So thank you so much for that. Just a little bit of housekeeping. This webinar is AAERT approved for you to earn your CEU credits. So just please make sure you stay for the entire hour so you can earn your credits. We will be sending you a survey to complete tomorrow so that you can then receive your certificate, and you'll submit that then over to AAERT. And we have some great discussion points coming for you. I love the topic that we have for tonight because the situations we're going to be talking about they're real. They're tough, they're uncomfortable, but they're vital. They're vital to our success in securing the record and keeping it at the highest standard, which is what we all want. The answers we will go through tonight, they're not all easy answers. And they're not all black and white answers. There is some gray, depending on the specifics of the situation and maybe even by state. But have no fear. We are going to give you insight on specific situations that you can apply in similar situations throughout your career. And in addition to that, we're going to send you a cheat sheet of sorts that you can refer to on your own time. We'll send it to you after the webinar, and you can keep it as a reference, a tool to help you think through uncomfortable situations as a kind of strategy session. I'm not going to go through it in detail, but I would like to encourage you to take note of some of the key things you're going to hear in the panelist answers tonight. You'll see how they apply the mantras of stay calm, kind of what I'm trying to tell myself now. Stay neutral. Don't assume, and prioritize the issues. So keep an eye out for this to come to you in an email from us tomorrow, along with that survey that I told you about. All right, so what do you say? How about we meet our panelists? And thank you, ladies, so much for joining us. And I have to say, what a beautiful panel that you guys all make. And you guys, you attendees out there, I have to let you know these people are beautiful from the inside out. Not only do they bring tremendous expertise and brilliant brains to us, but they are wonderful people. And I would encourage you to reach out to them as your fellow peers that have a genuine interest in the industry. So reaching out and networking is such a fabulous thing. And we have a great group here for you to get to know and to do that with. Merritt, how about you kick us off on our introductions? Would you mind telling us a little bit about your experience in the court reporting industry?
Absolutely. So I'm currently the director here at BlueLedge. I'm the lead educator for digital reporting and transcription. I am currently the certification chair for AAERT, and I am certified as a certified electronic reporter, and certified deposition reporter. I got started in the court reporting industry about 12 years ago. I was working at the court reporting agency. I worked in multiple departments like scheduling, transcript production, videography even. And that's when about 10 years ago, I trained to become a digital reporter. And like Tamara said, I just fell in love. I started training other digital reporters in my state and creating manuals and help tips and tricks, and it was just such a perfect segue into me starting at BlueLedge and offering online training to digital reporters and transcriptionists anywhere. So I am glad to be here tonight. Thank you all for joining us.
Awesome. Thank you, Merritt. How about Sandra? Would you like to go next?
Yes, my name is Sandra Munoz. I freelance as a certified electronic reporter, transcriptionist, and scopist. I started scoping on the side as a way to just make some extra money, and then soon learned about digital reporting, and then that became a passion for me. I am by no means an expert, especially compared to these industry experts surrounding me, but I look forward to hearing from you and learning together tonight.
Very nice. Thank you, Sandra. And you definitely shortchange yourself because you go beyond your years and experience with your thinking and the way you handle situations. So let's go to the other Sandra, who is so kindly going by Sandy for us tonight. Sandy, could you introduce yourself?
Sure. My name is Sandy Wilson, and I've been in the court reporting field for about 30 years now. I started off in California as a CSR. I had my own firm for about 10 years that I had started just right after I passed my CSR exam. And eventually I sold my business, moved to Florida, and started working for one of the larger court reporting agencies, and went into a lot of managing stenographic reporters, voice reporters. And then in about 2017, we started having digital reporters. So I got very involved in the training there, and eventually was able to actually take over the training program, develop my own program. So I was creating curriculum and facilitating. And I'm currently with Planet Depots. I'm their Senior Director of Litigation Technology. And that is the department that houses all of the digital court reporter training. So I am certified as a stenographic reporter and a electronic reporter and a deposition reporter. And I love the court reporting field. It's been a great career path for me, and I'm very excited to be here tonight.
Perfect. Thank you. Appreciate that so much. Miss Rosalie, last certainly not least at all, can you please introduce yourself?
Sure. My name is Rosalie Kromp, and I've been reporting for 42 years as a steno reporter, and I'm very proud to be here with all of the DRs, and I'm actually super impressed with everything you all do. So my background, I became a court reporter at 21. I started a court reporting firm at 25, and I reported everything, and I've probably done over, I don't know, 10,000, 20,000 depositions. I also was the president of DRA and the president of STAR. And I wrote a blog for many, many years that just gave information to court reporters how to deal with different situations that might come up in a deposition. And it's always been my goal to help my fellow reporters in any way I can, because I love this profession. It's the best profession on the planet. So tonight I'm going to answer these questions with a lot of experience, and thank you for having me be on your panel.
Absolutely. Thank you for joining us. We're so happy to have your experience and your perspective. It's definitely valuable. So thank you. How about we get to know our attendees a little bit tonight? So we do have a very quick poll we're going to throw out to you guys to see how many years of experience do you have in the court reporting industry? So we'll give you a few seconds to go through and answer that. Let's get an idea of the depth that we all have walking on this same, sometimes crazy journey together. It's part of what we love, right? All right. Let's see, we can go ahead and try to see if we have some answers now and post that. Wow, very nice. All right. So we got 36% less than 1 year. So a lot of great advice and insight that you'll get today from a lot of knowledge from everyone else. And look at that, over 10 years, we still have 15%. We're always learning, right? There's always benefit to hearing from others and what has worked from them. So fabulous. Thank you so much. I appreciate that. And we'll ask one more question too, to kind of get a gauge. Have you personally been in a situation confronted with a dilemma that caught you off guard? So yes or no. And maybe you have and you don't know, and you'll know after this webinar. All right. Thank you everybody for taking time to answer this. We appreciate it. Let's go ahead and we'll see what you guys had to say. Nice. Yeah, 62%. Very good. And I'm wondering if that 38% correlates a lot to the ones that haven't been in it quite as long, maybe. So very good. Thank you. Very valuable information that we get to go through today. So thank you everyone for joining us. Let's go ahead and kick it off and start in with some questions. Let's see. So Rosalie, I think I'm going to start off with you first. Looking at everything we're going into, remote proceedings, sometimes it can make exhibit handling tricky, specifically on the retention of exhibits for the transcript. Have you seen this to be an issue? And if so, what advice would you give to help reporters to secure those exhibits for the transcript?
Yes, and I feel attorneys and paralegals are happy when reporters help them, give them some guidance as to the exhibits. So obviously we know people mark their exhibits 1, 2, 3, 4. And sometimes attorneys have a habit of not saying the number when they mark an exhibit. They'll say, here, witness is a letter. And therefore the record is not very clear. And you understand that later someone's not going to know what's that's supposed to be marked as an exhibit or what. So a lot of times I'll throw myself in and say, and write the reporter exhibit 1. And so it gives it a little bit of a tip to the attorney that maybe they should have said something. And if the attorney keeps doing that, and once again, for the second document says, here's an email, I will just start knowing that I need to help this guy make a record or this woman. So I will say exhibit 1. Would you like that to be exhibit 2? Would you like that to be exhibit, and put that in the record? So later when someone's searching the record, they can find where these exhibits are, because otherwise it's really ambiguous. And then another thing is chasing exhibits. So after the deposition, you give your email address in the chat box and you say, please send me the exhibits 1 through 3 or whatever it is. Send me the exhibits, and you don't find them. They're not coming to you. And then you might have to write an email a day later or 2 days later, or the transcripts do, and you're writing emails saying, where are my exhibits? So what I started doing is during the deposition, I will set up an email to the noticing attorney, and with the subject line of the name of the witness, the date, and then say, dear attorney, I was your court reporter today at the deposition of Mr. Miller, and you marked exhibits 1 through 10. So I invite you please to return this email with all the exhibits. So that way it gets them less thinking that, where was that court reporter's email? And also it prompts them. And if you do it immediately after the deposition is over, usually those exhibits are on their desktop or somewhere that's familiar to them. So it's easy for them to populate that email request and send it back to you. And that's been really effective. Sometimes attorneys get this funny idea that you're going to add documents that maybe weren't actually marked during the deposition because maybe they forgot and they were hoping maybe they can get it in there, or I don't know what they're thinking. But you'll get exhibits 1 through 10 and all of a sudden there's 11, 12, 13, and that was never marked or identified during a deposition. So I will write back to the attorney and say, excuse me, but only exhibits 1 through 10 were marked. There was no 11, 12, 13. And they might write back and say, well, I would like those to be exhibits. And then I will say, all right, you need to get an agreement with the other attorneys that those could be exhibits. Otherwise, I'm going to not attach them, or I'm going to put them in the record as documents attached. And I also give them a date certain when I want that stipulation back, because it could be 2 weeks, 3 weeks, 4 weeks, and you need to get that transcript out. So I say, you need to get me this agreement by Friday, August 10. And otherwise, I'm going to assume that these exhibits were not marked, or these documents are not going to be exhibits. So that way you're able to get your transcript out and you're not waiting forever. And those are just a couple of the tricks that I use to deal with some of the things that come up with the exhibits.
That's perfect. I love it. And those have all personally happened to me. Absolutely 100%. And it happens a lot. So it's great to know what you can do proactively to kind of hedge that off a little bit. Merritt, same thing too. So like when someone does try to, maybe they are trying to sneak in exhibits that they didn't mark during the proceeding, or maybe it's just something that truly was an oversight and they want it handled in there. What do you do if they send you additional exhibits that were not covered in the proceeding? Do you kind of do the same thing and email back to them, or do you have to copy the other attorney?
I think what Rosalie said was beautiful. Something else you could do is just make, well, she said this too, like make them attachments, not exhibits. So, and making that clear to the attorney requesting it. But I like her example of like going a step further to try to get them to become exhibits before the transcript is completed and submitted to them.
Same. Yeah, perfect.
I'd like to add one other thing about exhibits. If you don't leave the proceeding with exhibits, which is much more common with remote proceedings, it's absolutely recommended that you get a stipulation on the record who has them. And then if somebody's going to be sending them to you later, maybe that they're going to be sending it, or maybe they're never planning on giving it to you, and getting that on the record is important too.
Yeah,
That's particularly with the doctor's deposition and the doctor says, I'll send you my file in 2 weeks or a week, and then it never happens. So another thing I'll do is in the index, I'll write exhibit 4 doctor's file, and then I'll put a parenthetical, not attached, never sent to the court reporter, or something that explains to whomever is looking at this transcript what happened.
Yeah, great. And we have one question that someone submitted. It says, do you ask the attorney if they wanted to mark an exhibit as soon as he hands it over, or do you wait until he's finished with that document?
I think you need to know the flow of the attorney. If they're excited about talking about the document, let them do it. But when they're take a breath, you can say, was that exhibit 1? And they'll go, oh yeah, of course it was. So, thank you, counsel. And then I also keep track, because a lot of them are getting confused, I feel. So even though we have enough to do, I do write down 1, 2, 3, 4, 5. And sometimes I'll jump to 8, 9, 10. And then at the end of the deposition, I'll say, excuse me, counsel, but I just want to note that there was no 6 or 8 today on the record that were marked, no documents with those numbers attached to them. And so I say that out loud, so everyone's on the same page when the index comes out and there's documents missing.
Perfect. Okay, thank you. Okay, so let's see. Another thing that can commonly happen on remote, but I'm sure in person as well. I'm going to ask you this one, Sandra. What do you do if you notice the witness attorney is telling the witness how to answer while on the record? Maybe the taking attorney's telephonic, maybe he's just not noticing. What do you do? How do you handle that?
I had that situation not too long ago. I could hear in the confidence monitoring somebody quietly talking, and the attorney didn't seem to notice. The taking attorney kept asking questions, and I would hear an answer, and then I would hear the answer again from the witness. And so I was thinking, I really need to say something. I know that this is an ethical dilemma that needs to be addressed. And so I was trying to figure out how to kind of delicately handle that. And finally, as soon as he took a break or, stopped talking, I said, for the appearances page, I just need to get the name of the other person who's in the room, who's off camera. And he said, oh, there's someone else in the room. And I said, oh, I'm hearing another voice. And when the witness said, oh yeah, my mother's here in the room with me. So it was handled, fortunately, quite easily, but definitely something that I thought needed to be addressed.
Yeah, that's a nice discreet way to do it as well, right? Kind of just see what happens and see how it goes. Because it's kind of interesting. Do you have any thoughts on that, Sandy, as well? Like, do you think you should speak up and say something in the middle, or just kind of discreetly see if they know?
No, I think Sandra just explained it beautifully. If you hear something, then it's being picked up on the audio. It is part of the record. No matter what method of reporting you're using, if you hear it, it goes in the record. And so finding out who that other speaker is really important so that they know. I would do it right off the bat so that if it's someone that they don't want speaking, because normally in a deposition, they're not going to just let anybody in the room. Like the parties have to agree for non-parties to be in the room. So if that person is a non-party, the attorneys have say so, and they can say no non-parties attend this deposition. So you absolutely have to identify it. And I would say the sooner the better.
I agree.
That's
I
perfect.
said, in remote depositions, I'll ask a witness, is there anyone else in the room with you? Or even to the attorneys, is there anyone else in the room with you? Because I need to get that from my appearances. And sometimes, oh, here's my mom, or, and then they tell her, get out of there.
That's a perfect preemptive way. I like that. Part of your housekeeping, right?
I've had a similar situation, but it was more the attorney. So it was me, witness's attorney, and the witness in the same room, and then taking attorney was remote. And the witness's attorney was writing down on a piece of paper kind of what the witness should say, but the taking attorney didn't notice that. That I did feel like is not my place. I don't need to be getting in the middle of anything like that. So I think, yeah, that's not something we have to get involved in. But I think absolutely, if there's somebody else in the room we're not aware of, we got to get that on the appearance page.
There was a situation in California in which a reporter was bilingual, and so she could understand Spanish, and she, let's say the reporter knows that this is bad translation, or there was a lunch and the attorney and the witness are talking, and then they ask the reporter, what did you hear? So the reporters really need to say neutral. Merritt's 100% right. We can't jump in and say, hey, they're showing papers. Hey, you can't cheat. We just got to be Switzerland all the time.
I like it. Nice. Okay, well, we actually have another question in the chat box. It's right in line with where I was headed next on a slightly different spin. So let me ask this one first. Raymond Betts is asking, how would you respond to a request for a CNA from an attorney or employer from a deposition that no one appeared for at all on remote? The counsel didn't appear, the witness didn't appear, only the reporter's there, and they want a CNA. Who would love to take that one? Sandy? Okay, go ahead, Rosalie.
I'm sorry.
Go for it.
Sorry, I have a. I sat on the Court Reporters Board of California for a couple of years, and a reporter lost her license or had it suspended because there was a CNA, and the attorney said, "Can you just write that I was there?" And wasn't there. And so it seems like, what's the harm? But bottom line is, you really need to be honest. So if you're doing a certificate of non-appearance and no one's there, there can be no one. There's a certificate you could do that says you showed up and you were alone, but you cannot start saying that anyone else is there or anyone is directing you. And usually you have to be super careful, no matter how much the attorney says, oh, come on, it doesn't matter. Come on, please, please, please. Don't do it.
I love that, because you got to always respect, and I used to say this to my reporters all the time too, it's your notary on the line, right? Not even the agency, not anybody else, it's the notary. So you got to protect yourself and your career in that sense too. So I love that advice. Sandy, did you have any other thoughts or anything in line with that?
Yeah, I was just thinking, because I've had attorneys ask for CNAs on other attorneys. I've had, now I think it's okay if somebody says, I don't think this witness is going to show, call me if they show. And if they don't show, they ask for a CNA. As long as you're there at the location or wherever you're supposed to be, and the witness doesn't show, you can do a CNA. You were the only one there. Like, you're not going to say that any of the counsel was there. You could, if they're waiting on the phone on hold or something like that. But like Rosalie said, just tell the truth, because you are certifying. This is as if you're in court testifying. You are certifying. So do not fudge the truth at all. But if you were there and you waited 30 minutes and the witness didn't show, then sure, that's a legitimate CNA, even if none of the counsel showed up. And it is okay to do a CNA on, if an attorney says, like maybe they've set a deposition 3 or 4 times and opposing counsel keeps not showing up, so then they can't go forward with the deposition, you can do a CNA and say who was present and who wasn't present. Like, you're not throwing anybody under the bus. You can state you were there, if the witness was there, who was there. and so was not there, and then that attorney can take that to court to compel that attorney to either substitute counsel or get to the deposition. But that's okay. The first time that happened to me, I was like, that's weird. But everybody's like, no, you can do that. You're just certifying who was there and who wasn't there, but you don't need to go into a lot of detail.
Okay, so being specific in the
Yeah.
wording of the CNA sounds like that's kind of the key point there.
Sometimes you just have to tweak it to the situation. It's not always going to fit that perfect template that maybe you got from your office. So make sure you read it and you're not just throwing information like a witness name and a date on it. Read it and make sure it actually reflects what happened, because those will be filed in court.
Perfect. I love that. So it kind of goes along with our thought, our mantra of think through your priorities, right? You have a template, don't just send it out there and go for it. You got to think through what's important, work on it, analyze what you're doing before you do it. We're going to move on to another topic now that's, I would say, one of the, I don't know, scariest that happened to a reporter, because it's right in the moment. You got to make that decision. And man, can it be rough? It can make some people mad. What if you have conflict over whether you're going on the record or off the record? And we'll start with the first. What if you're in a deposition and one attorney wants to go off the record, but the other one doesn't? Sandra, would you like to answer this one for us?
Well, in a deposition, I believe all parties need to agree to go off the record. So, usually I will say something like, are there any objections to going off the record, which is their chance to state their objection. Absent any objections, then yes, we can go off the record. If there are objections, we continue on the record. And that's just following the guidelines of AAERT.
Perfect. I love that plug there. That's nice. We have the information for us and some of these things where we can do it. We just have to apply it and be brave, right? It definitely takes some nerve to stand up. And this is a good point too. So Rosalie, what if it's the taking attorney, the hiring attorney that brought you to the job that is demanding to go off the record?
That's happened to me. It's happened to my reporters, and you just have to be strong and say, no, the law says I have to stay on the record as long as anyone in this room wants to be on the record. And then they start screaming, no, I want you to be off the record. No, yeah. And I have to be on the record, and I'll just put my head down and not answer. And I had one attorney, why aren't you telling me? Why aren't you talking to me? And I can't talk and right at the same time. But bottom line is you stick to your ground. You know the law. They know they're being bad. And I know I know attorneys really do respect you. They respect the heck out of you if you do what's right. And another thing I always tell attorneys when they ask me to do things that I know are wrong, I say, you know what? My goal in life is to do the right thing at every situation. And if I'm wrong in the situation, my goal is to do the right thing. But you all know, don't go off the record unless everyone agrees to go off the record. And I had a situation where it was a videotaped deposition and the attorney got all mad and went outside. And so you would maybe assume you're off the record, but the other guy doesn't want to be off the record. So even if someone leaves the room, in my opinion, you have to sit there and stay on the record, even though nothing's being said. So yeah, it's a very strict rule.
Yeah, I see you shaking your head. You're agreeing, Sandy. What are your thoughts on that? Because that has happened. What if the attorney storms out or clicks off the remote meeting and they're gone? What do you do?
That's a strategy, and they didn't all agree to go off the record. Just because someone ran out of the room, it doesn't mean that you're off the record. People come and go out of depositions all the time. So I agree. I also have had situations as a stenographic reporter in California. I don't know what's up with California, but where the attorneys are like screaming at me, where literally an attorney got up out of his chair and got in my face and was demanding me to go off the record. And I just kept typing. I just kept my head down and I just kept typing. And finally, my client said, off the record for one moment, and asked me if I was okay. And I said, I'm fine. And he put us back, he was just like, are you okay? I'm okay. And then they just kept fighting. But yeah, I finally raised my hands and said, counsel, I cannot go off the record until everyone agrees. And as long as you're talking, I must stay, keep writing. And then they just kept fighting and fighting. And one of them did get up and run out of the room. And then he just kept questioning the witness because they did not agree to go off the record. So you have to stick to your guns. They will try to intimidate you, just like they try to get notaries to swear witnesses in over the phone. They know that you're not supposed to do it unless like you're from a state that has mandatory certification that actually gives you that authority to swear in over the phone, but notaries can't, and they know that. And And so you know the law, and you always do what's right, because that it doesn't matter if they're mad at you, because even if you make everybody happy, but you're doing the wrong thing, someone's going to turn you in. And ultimately, it's your job, it's your notary. So you always do the right thing no matter what.
And you will be so respected, I promise.
Can I add one thing to that?
Please. Yeah.
The situation was the attorneys began fighting, and then a partner walked into the room. So I stuck with my, for appearances, could I have your name, please? In the middle of the fight. And then they decided to call the judge. And the judge came onto the speakerphone through Zoom. And I said, for the appearances, could I have the judge's name, please? And it became almost like a circus, but I think it also kind of helped break the fight a little bit, because they had to pay attention for a second to what I needed.
It reminds them that they're on the record, because they forget that you're trying to create a record. So that's
Right. By the way, there's evidence of you acting like that. I'm just saying. Perfect. Okay, so let's take this similar situation, but we'll spin it just a little bit. What about for EUOs, examination under oath? So the rules are a little bit different. It's not under civil procedure. Merritt, what do you do? Like, so the examiner wants to go off the record. The witness happens to have an attorney and they don't want to go off the record. What's the solution?
It's a really good question. So for examinations under oath, those are considered work product of the hiring investigator party. Oh, technically not parties yet. Investigator, attorney, the person who hired you. So if they are the ones telling you to go off the record, you can, even if other people don't agree in the room, because it's work product. The hiring party can make that decision. So but for depositions, back to what everybody else was just saying, they have to agree.
And
Perfect.
There's one thing, and I don't know, I know in California, if one of the attorneys does say, I'm going to get a protective order, then you are allowed, you're told, stop in California. So if you hear the words protective order, that says you better stop writing, because they're going to the judge.
Great.
And you should announce that. You should say the court reporter or the deposition officer is taking this off the record, so counsel can seek a protective order, and you do your hands like this so they know that you are not writing anything else down.
I was going to mention, I love that you were doing this before. So I learned that kind of recently, actually. That's definitely a great thing the stenographers have. Like, hello, I'm not typing. So we can use that too as an alert, right? Like,
It's a quiet way of stopping the chaos, because when there's a lot of people arguing, another voice being in there makes it even worse. But the minute the court reporter does this, that will get their attention, even if they're not looking at you and they see your hands up in there, they're going to be like, what? So that does make them stop. And then it gives you a moment to say, counsel, the record is suffering. Perfect. And then it kind of like pulls everybody back into order. So.
Okay. Thank you. All right. So let's see. These are all situations where you guys have outlined the reporters followed all the protocol. They've done what they're supposed to do, but the attorney is just so upset. And one example, even yelling in your ear. What's a good tip or advice that you could give the reporter, Merritt, for a situation like this?
So when dealing with an angry client or person in life, the first thing you should always do is acknowledge their frustration. Like, make sure they feel heard. I'm sorry for this frustrating situation. And this is regardless of who you think is in the right or the wrong. And you do what you can to solve the situation, again, regardless of who is in the right or the wrong. And I think one of the most important parts to, making the client feel whole afterward is to follow up with them, if that's appropriate, or maybe the office follow up with them to make sure, kind of full circle, if it's something that can be fixed for the future, that type of thing. Like maybe they have a special request that maybe they want done in the future. So maybe you tell the office so they can tell the next reporter to do that type of thing.
That's great. I love that. Hey, great way to be a valued reporter as you're thinking about your agency as well and their clients and their client care, right? So that's a perfect tip. I love that. Okay, well, let's see. So let's go to one that can kind of be a little bit, definitely one of the gray areas. It's very black and white by state. But if you're talking in general, it gets kind of tricky. Anything under the notaries and swearing in and what comes along with that. But we're going to touch on, what if a witness doesn't have their ID, but the attorney says that's fine, just swear them in anyway? Do you still put them under oath? Or do you state anything regarding the issue on the read-in? Sandra, would you mind answering this one for us?
I will try. It's a very sticky situation, and I agree with you. I believe it varies by state. For me, I think it's important to consult with your state guidelines for your notary commission, because that's your commission that's on the line. I think it's different in different situations. So, I don't really have a clear answer for that.
I like the answer you gave.
Yeah,
Sorry,
when
go
it's
ahead.
happened to me before, I basically just pull out my state notary guidelines and quote from certain pages.
Yeah, I think it's important. And it's one of the things, quite honestly, just knowing you, that I love that you bring up a lot, because an important part of being a reporter is knowing your notary rules, right? It's not just your reporter guidelines and how to be a reporter, but you need to know what you are allowed to do with your state. And you can reach out to different resources and find out from that way. So I think that's great. Make sure you're educated beforehand. We have a specific question in the chat box. I'm not sure if we'll be able to answer it specific to, it looks like to New York. I'm going to read the question and we'll see. It says, how can I best handle when the plaintiff attorney does not want his witness to show a government ID? This is a new requirement in New York, part of the e-notary. Is there anybody that is familiar with New York, or maybe just kind of in general advice, maybe as then kind of being specific how to handle it with your agency or the state?
It sounds like the question said that it's a requirement.
It's new, I think. I would suggest you talk to the firm, or if your local association, your state association, because I know this is a new law that just came in, and I know they're being very strict about it. So I definitely would find out the details as to what it encompasses.
And something I want to add to this is, I think what is so important is that we have a community, so we can reach out to people in our state for these kinds of questions. Like, so do what you can to find another digital reporter or steno reporter to, build that mentor-mentee relationship, or just friendly colleagues, so you can talk to each other about these types of things. I did see a question, does anyone know if in California we need to ID witness? Also, do we need to log it in our notary log? I'm not sure about California specifically about the checking the ID, but I do remember learning that you do need to log it in your notary log in California. So wanted to share that.
Sandy, you're shaking your head, same as.
Yeah, I'm sure that California has to keep a notary law of every notarial act that they do. It has to be kept in a journal. And I'm about 99% sure that they also have to ID the witnesses, that they need government issued ID. But again, you should know your notary rules for your state, because they are very different in every state.
Perfect. Okay. I see some other notary questions. We're going to move on. I'll come back to those at the end and see how we're going through here. Maybe a separate webinar. We can go crazy with notaries and IDs, since it gets very deep with those. I would definitely say. Let's look at
panelist from each state.
Yes, right. We'll just have like a whole 50 panels. So record omissions. Who can say what to remove or not remove on a record? What do you do if one attorney says to redact something after the other attorney has left for the day? So Sandy, can you answer that one for us? What would you do?
I would say, and I don't know that there's exact rules about this, but I think there's just best practices. So it may vary firm to firm or state to state, but when it comes to redacting something out of the record, that's going to take all of the parties coming into agreement on that. Someone can't tell you to take something out, like whether it's a curse word or maybe it's somebody's private information that they're like, oh, I forgot to say redact that out. If there's something that they approach you with after the fact, then I would just gently let them know that you're going to need agreement of all the parties. And if they can't come to an agreement, to see the judge. And then they can either bring you a court order, or they can all come together in one email and tell you that the parties have agreed to do this. But you never do anything ex parte, never take anything out of the transcript because just one person asks you to do it.
Okay, perfect. Anything to add, anyone on that one? Seems pretty covered it all for us. All right, great. So let's see. Okay, here's the situation, and I'm going to throw this one to you, Sandra. What do you do if the attorney is asking back and forth question and answer with the witness? Very quickly, they say, off the record, what is your social security number? And the witness answers. Then the attorney, before you've even had a chance to say or do anything, they're on the record and they continue on again. How do you personally handle that situation?
Usually, I'll just make a note in the annotations, or I'm very quick on the recording button so that I can stop that recording. However, I had an interesting situation that happened not too long ago where they asked for a phone number, which was supposed to be on the record. The witness was a little bit older and very nervous and gave a 9-digit number that I thought, wow, that doesn't sound like a phone number. And suddenly the attorney for the witness said, oh, she just gave her social security number. Can you take that out? And so the other attorney agreed. And so I just quickly, made sure that I said on the record, the social security number is being redacted. And then she went on to give her phone number on the record.
Oh, great. Perfect. Make sure it's very clear. I like that. Mary, if it happens like that, is it worth interrupting them to say something? If they've said off the record on, you didn't get to say anything back, should you stop them?
If it's just happened so quickly and you just didn't get a chance to interject, I don't think you need to try to interject in that moment. Just make really clear notes for the transcriptionist if you're not going to be transcribing it yourself, or better yet, make the notes for yourself too. But like that part wouldn't be in the transcript, and making that very clear. But better yet, not do it during your housekeeping before the proceeding begins, telling the attorneys and witness that you will be verbally saying when you're going on and off the record, so that they're aware that you would do that, will hopefully get them to follow that, but just know that they still might not. So
can
Okay,
I also
perfect.
add to that?
Yeah, of course.
And in the same way, what you just said, I make a note, and I also send a separate note to the production or transcription, letting them know to please make note of that annotation that said to redact that recorded material that was recorded accidentally.
Perfect. I see your thumbs up, Rosalie.
Yeah.
You're in agreement. Any extra tips?
No, I mean, obviously we can go like this real fast. You have a much more difficult situation. And but yeah, and once again, attorneys, particularly with it comes to social security numbers or addresses, they're going to also try to protect. I think there's actually federal law that says you can't put those kind of things into a transcript. So I don't think you're ever going to have a trouble. And actually, they'll respect you if you agree and just do what Sandra suggested and make sure it's just very clear on the record what happened.
Perfect. Okay, so the next hot topic that can be an interesting one to navigate around is off the record discussions and how to handle those. So let's give a scenario. I'll throw this one to you, Sandy. Say you're on a break. One attorney's still at lunch and the other one has come back into the room. You're in there setting up, getting ready to go back on the record. And they ask you to play back part of the audio where they think the other attorney might have said like a curse word or something and they want to hear it. What do you do?
There's a couple of different ways that you can handle that. One scenario would be that you go ahead and find that part of the testimony that they're looking for and play it for them. And then just let them know that you'll also make that information available to the other parties when they come back in the room. It's the same thought process as we've got to offer the same services to all the parties. I personally didn't like doing that. When people asked, I would always say, I'll cue it up, and when the parties come in, I'll play it for everybody. But you could do it if it's, maybe it's an hour lunch and they're not going to be there for a while. You could do it as long as you just offer it to the other parties so that everybody hears what was played back. Because I feel like that's a little bit sneaky if they're asking you for information in the transcript when no one else is around, especially if it's against like the attorney, like because they said a curse word or something like that.
Perfect.
What
So keep
what I
keeping
do
in
to
mind.
I'm sorry. What
No,
I do
go
to
for it.
what I do is I will say, all right, I can read back that portion of the transcript, but I want you to know that I'm going to also be reading it back when the other attorneys come in and say that Mr. Miller requested that this be read back. And sometimes they back off like, no, okay, never mind. But so just so they know that everyone's going to be hearing whatever it is that you're going to play back.
Perfect.
Or you could even play innocent, like, well, since I'll need to play this back for the other parties when they get here, do you want me just to do it all at once when everybody's present, or do you want to hear it now and then hear it again? So act like you don't want to put them out, but it's basically letting them know that everybody's going to know what you're having to play back. So.
And in the remote environment, it's a little bit easier because we can just stay off camera during the break.
Right. Proactively hide until you don't have to.
I think you should always have headphones on no matter what. You should never be in a room with one party alone or with the witness alone if you can help it. But if you do need to work on something, put headphones on and just pretend like you're doing something else so that if they're having an off the record discussion, you can say, I didn't hear, or they'll think you're doing something else or busy yourself on the phone or whatever, but try to not be alone with just one party or one witness.
Perfect. I love that. I've heard Merritt say that several times too, and I love it. Like, keep busy, look busy. I like it. That's great. And it's nice. It helps us to stay neutral, right? We're not there to help one party know something that any other party does. So if you just remember to stay neutral, then whatever you do from one, you have to do for the other, right?
One thing I've done in remote depositions too is I ask permission before a deposition starts. If during a break I can mute people because we have the power. And so because sometimes particularly older people, they just start talking and that's not supposed to be heard by everyone. So I ask everyone while everyone's on the screen, I say, do I have permission to mute people when I feel like it's off, we're at a break and someone just forgot to mute themselves, and everyone's so grateful. So that's just a trick I do too, so you don't end up in hearing something you don't want to hear.
Great tip. Yeah, it makes it very uncomfortable when that happens. What do you say? Have you guys ever had something when a client comes up and maybe tries to joke about something the witness said, or maybe they're even asking you, what do you think about this witness? Do you think they're credible? Merritt, what would you do if that happens?
Well, it's happened multiple times, and it's tough because you think like they're your client, you want, to have a good relationship with them. But at the end of the day, you have to stay neutral because that's your number one job as the court reporter. So I always just as politely as I can tell them, unfortunately, I'm not allowed to have an opinion on the case. So and
I like it.
make a joke out of it if I can, if I'm feeling funny that day.
Perfect. I'm not denying you. I'm just not allowed to. So that's end of story. Great. Okay, so what if none of the parties order the transcript when you're on the record? You did what you're supposed to do. You asked for orders on the record, so it's clear. And then the attorney comes back after the proceeding and tells you that they want to order a transcript and they want to expedite it, but they ask you not to tell the other parties. Sandra, what would you do with that?
Whoa, that's something I would probably refer them to the agency directly to place that order. And I think it also depends on, I know in some states, the other party needs to be notified, especially if they, ordered read if ordered. And so I think, again, the agency is probably better equipped to handle that if there's a production issue.
Perfect. And I've seen that too. I've practiced it. If you're emailing or talking to one attorney, you might as well always make sure you have all parties and all attorneys on there. Would you agree with that, Rosalie?
Yes, some attorneys will say, I'm going to expedite this, but don't let anyone know that you're getting it to me tomorrow because there's a hearing Wednesday, and you're going to be in big trouble if you let anything like that happen. So I don't care if it's your best client you've ever had, and you have to be transparent and let everyone know that the transcript is available on this particular date. And you can let the person know. I have to let everyone know it's the law. I use that a lot. It's the law. And or rough drafts, whatever it is, you have to let everyone know when it's available and give everyone the same opportunity to have it available at the same time. And that goes with exhibits too. Sometimes I've had attorneys say, can you just give me all the exhibits tonight and don't give it to the other people? And say, no, I cannot. But they do that kind of stuff. Just always know you are correct. Your instincts are correct, and just say no.
Okay,
You
perfect.
can also tell them that if the shoe were on the other foot, if it was opposing counsel that was asking the same thing, you would show that same courtesy towards them. So they have to know that both sides are doing that to the reporter, which is why you're remaining neutral, which is why you're going to follow the rules. So I think when you say, like, if the other counsel came to me and asked the same thing, I would not, get the transcript to them and not tell you. So that kind of puts it in perspective for them.
I like that. That's perfect. Let's see. So we talked a little bit about the attorneys arguing back and forth a little bit. What if they're not necessarily arguing, but it's a lot of crosstalk, keep mentioning it, and they're still doing it and still talking over each other? How do you handle that? Do you still keep interrupting them ad nauseum? How do you finally put an end to it? Sandy, would you like to answer that one for us?
Sandra keeps doing this.
Sandra's like, I got it. I know now.
Yeah, what I did when I was a reporter is I would definitely very politely and calmly, multiple times, ask them to speak one at a time. I would let them know the record is suffering. If a couple of times I had an attorney say, do not interrupt me again. So if they say, do not interrupt me again, then I wouldn't interrupt them again. And the record would be poor, and that would be on them. And the judge will see that, because the judge is going to see the court reporter asking them to not talk over each other over and over and over. If they're not being, that aggressive about it, but they still are not heeding the warning, then again, after you've put yourself on the record multiple times, you do this and it's not like a violent, it's a very, just like, I'm just letting you know that I'm not taking the record down. And when they look at you, just say, counsel, the record is suffering. But sometimes you have to just let it go after a while. Like, I would say 3 or 4 good warnings. And then at that point, the next time you take a break, I would definitely address the parties when everyone is in the room, just very, politely and professionally let them know, counsel, before we go back on the record, I'd like to ask you again to please speak one at a time, because the record is suffering. And at least you're doing it, you're not interrupting them again, but you do have to kind of take that risk of sometimes irritating them. But your number one job is to get a verbatim record. So I think I would lean more on the side of irritating them than letting the record just go bad. But sometimes if they're making a bad record, then the record's just going to be bad. So you have to sort of use your judgment in the situation.
Okay.
And I feel Sandy's 100% right. You need to put yourself in the record. A lot of reporters ask, like, the reporter, please slow down. Reporter, please don't interrupt. So that anyone reading this transcript can see you're trying really hard to control these people. And so it is important to put yourself in when you do interrupt. And actually, to do, I guess, a little commercial, I just did with Jan Ballman, she's out of Minneapolis. We just did a depot talk of the art of interrupting and how to do it at depositions. So you're not making people mad, because, there's just little tricks you could probably do. But the bottom line is, Sandy's right. It's their record that you said, it's your record. I'm only doing this for your record because I want to give you a beautiful record. And some of them don't care because they just have bad habits, or they're not mindful, or they're just angry people. So
That's great. Hey, that's a webinar I'm going to go watch myself. That sounds perfect. The art of interrupting can be helpful in anything, not even just proceedings, right?
You really should practice what you're going to say too, because you start getting really stressed when they're yelling and you start seeing your record kind of going down the tubes, and you don't want to blurt out something that you can't take back. So yeah.
Would you just stop?
So, yeah. For the love of God. But practice what you're going to say and make it very short. Don't get into a big long, they don't want to hear you talk, but do practice it, because when it happens, even if you have to put it on a Post-it and just look at it and say those 4 words or whatever it is, but don't go into a long, dialogue.
I love that. That's part of on our sheet too. You don't want to be the record, right? You're just trying to get little imbits. If you have to interrupt, try to make it short and sweet. That's great advice. Definitely. We're getting really close to the end of our time. We still have some questions to go through, but I want to make sure we hit some of the questions in the inbox that we have coming from people as well. I'm going to ask one that Carrie Cox has sent in. It says, what do you do when an attorney asks to mark a portion of the testimony confidential, but then doesn't ever tell you when the portion ends? Merritt, can you throw this one at us?
So as the reporter, absolutely be as clear as possible. Say the beginning part of that again, if you don't mind. Like
Sure.
they tried to.
Yeah, so they said that they wanted a portion of it to be there, but they didn't ever tell you when it ended, when the confidential part ended.
You'd have to reach, if you're already not in the same room with them, then you'd have to reach out and get specifics so that you can, do it right for the transcript or tell the transcriptionist.
Okay, perfect. Okay, I'm going to ask this one. I didn't get to read the whole thing yet. It's from Anonymous. I had a job the other day where there was an interpreter on the case and there was a question posed, but the witness started to answer in Russian without the question being translated. When she was done speaking, I interrupted and said, I'm sorry, but I did not hear that question translated. Mrs. Interpreter, did you translate? And she said, no. Do you want me to? And I said, yes. Is that acceptable? Were they in their lines of what a reporter should do?
If I followed correctly, I think so. I mean, asking if it was in English or.
I would, obviously the attorneys are listening to this whole thing too, and they have some responsibility, in my opinion, to make their record. The fact that the person just started answering. So sometimes I will put a parenthetical in, speaks Russian, and then the witness, a colloquy as opposed to QA, and then go back into the QA. So people reading the transcript could understand that something happened. Obviously, I don't want to be a part of the record, like we're saying. So that's a really tricky thing. So I also will ask counsel and say, excuse me, counsel, but I really, we need to have the interpretation by the interpreter and then the answer. Otherwise, the record's going to be a big mess. And I might say that at a break because I don't want to be a part of the record once more. But a lot of attorneys don't know how to deal with interpreters. And so giving them some clues helps, but also you have to go into colloquy if they start speaking in Spanish, and I'll write in Spanish or in English TDD, but that's obviously a pain. So it's kind of a long answer.
To add to what she just said, I like that you said like give the interpreter little tips, but I would add to that, do it not in earshot of the attorneys or witness, like try to pull them aside maybe.
And I've also added that to my housekeeping. If there's an interpreter present, I will just say as part of the regular housekeeping, with an interpreter present, please allow additional time for all questions and answers to go through the interpreter.
Great.
It's just a reminder.
I like it. Okay, we have Brittany Hernandez has asked, when you have to use the restroom and you see a witness upset and ready to step out, how would you deal with a situation like this? So we're all people, but you are trying to stay neutral. How would you handle that situation? Sandy, do you have an answer for us?
I understand the question. I have to go to the restroom. What I don't understand about me. So
it sounds like to me you're on a break and you're going to the restroom where you see the witness there and they're upset and perhaps about to step out maybe of the restroom. Do you acknowledge that they're upset, try to console them, or how do you handle that?
Like you just take care of your business and go. I think you're just very polite. I would smile at them, acknowledge them, make eye contact, but I would not speak to them.
Okay.
Keep the
If
earphones.
they ask you, I'm in the bathroom with my earphones on. If they ask you a direct question, obviously you would answer it, but I would get out of the restroom like toot sweet, like I would not stay in there, because then they're going to go back and tell their attorney, well, the court reporter told me to do XYZ and now you are a witness. So that's a really sticky situation that you need to get out of as quickly as possible.
Yeah, the court reporter feels sorry for me because you're being mean to me, and you're like, what?
Yeah, could get out of control much faster than what you think, right? Or what you intend, certainly too. We have a great question from Katie Porter. Are reporters required to ID the interpreter before swearing them in? So let's see.
In California, you are. It's a new thing.
Even the interpreters?
And you have to put their certificate number in the record.
Okay, perfect. Go ahead, Marriott. Did you have something?
I was just talking with somebody the other day about that. I didn't do it, back when I was reporting, but I think you should, and why not,
Can't hurt. Better to be safe than sorry kind of thing.
I
Um,
think you have to for remote. I
Oh,
think
for
you have to for remote, yeah.
for
I
in
don't,
person, that's where I didn't when I was in person, but I
yeah.
guess should have, yeah, sorry.
It's a great question. And sometimes you don't know, right? So it's good to clarify and get the best practices and what can best secure you and help you. We do have more questions. We only have a minute to go, so I need to close things up a little bit. But what we will do is we do have these questions. We will find a way to try to answer them the best we can to you in an offline way to get that for you. And also we'll look at them. If there's a common theme in them, absolutely we'll take it into account for maybe it's a next webinar or something like that we can do. We also have a suggestion form and anything you can fill out to us at the end. If you have a question or a future topic you want to hear, by all means, please let us know because we do go through those and look at them and want to give you guys what you need and what you're looking for. So that's what we have for today. Thank you so much for all of our wonderful panelists, all the amazing answers and helpful tricks for all these sticky situations. You guys have been fabulous. And I really appreciate it. Everybody, all the attendees, thank you so much. Make sure you fill out your certificate. If you want to get your CEU, look for that to come from us tomorrow with all that information. And we hope you guys have a good night. Right?
Thank
Bye,
you.
everybody.
Sorry.